If there's one thing you would want to tell every family that has digital assets, what would it be?
I hate to say it, but I'd suggest think about the worst case scenario. Nobody wants this to happen, but just imagine that big blue bus outside has got your name on it and it's coming for you and you get taken out by the proverbial. So what would happen in that situation?
Have you ever wondered what happens to your Bitcoin or digital assets when you die? In this episode, I'm going to be sitting down with Anthony Hunt, the ex-Chief Operating Officer of Westpac Private Bank, who now runs a Sydney-based law firm called Wealth Lawyers. In this episode, we're going to cover everything from testamentary trusts, executor responsibilities, and what you need to know about digital assets and estate planning so that they get passed on to your loved ones. You won't want to miss this episode. Can you tell us a little bit about your background and what got you into the intersection of law, estate planning, and wealth management?
Sure. My background's a little unusual for a lawyer in that although I qualified and was admitted as a solicitor many years ago in 1991, I spent a long time working in the financial services industry itself in operational roles running businesses. So I was the Chief Operating Officer of the private bank at Westpac. I was a general manager of Perpetual Private, and I've had other sort of roles like that. So I spent a long time working in the industry, working with financial planners, with accountants and other people who operate in that space. And I now bring that experience to the practice of law as it relates to wealth. So our aim is to help people protect and structure and grow and transfer their wealth in a way that they really feel confident and happy about. And we work very closely with a lot of financial intermediaries in doing that.
We're going to be touching on the topic of digital assets a little bit later. Could you talk about what is a trust? What are the main different types?
Sure. In its essence, a trust is just a relationship where somebody that we call the trustee is responsible for looking after assets for other people called the beneficiaries. Now, that responsibility is one that legally is held to a very high standard. So the trustee has what are called fiduciary obligations, that they are accountable and responsible and must do everything in the best interests of the beneficiaries, the people for whom they're holding those assets, whatever they are. Now, the beauty of trusts is that they're very flexible. They can be used for lots of different reasons. In our business, we use them for asset protection. We use them for income planning. We use them for transferring assets. We use them for protecting and securing assets for a variety of reasons. So because they're very flexible and there are lots of things you can do with them, there are also different types of trusts. So people would be familiar with probably unit trusts, which are the sort of things where if you're going to invest in a managed fund, that's typically structured as a unit trust. It's a fixed trust where when you put your money in, you know exactly what your entitlement is and you know what your legal rights are. But then you would have heard probably more recently a lot of talk in the press after the budget about discretionary trusts and family trusts. So these are a different type of trust where the beneficiaries don't necessarily have a current entitlement to the assets that are in the trust. It depends on the discretion that the trustee can exercise. So the trustee effectively gets to choose how much income that each of the beneficiaries would get from the trust. That's why they're called a discretionary trust. But because of that, they're very useful for asset protection purposes because the beneficiaries are not currently entitled to the assets. So anybody who wants to claim from the beneficiaries because of they're being sued or a relationship's breaking up or various other reasons, the beneficiaries can say, well, I'm not entitled to this asset. It depends on what the trustee decides. So that's why they provide protection. Now, when we talk about estate planning, we get this term called a testamentary trust. And in a will, we can, will is you give your instructions about what you want to have happen with your assets when you pass away. If we create a trust in the will, that's called a testamentary trust. And it's like any other trust, and they're nearly always a discretionary trust because we give the person who's going to be the trustee the discretion to manage and look after the assets. But the big difference is those trusts don't come into existence until the person passes away. So that's in contrast to the other main type of discretionary trust, a family trust, where we set it up under a trust deed now, and the trust operates straight away. So in a testamentary trust, the one that's set up under a will, it only comes into existence when the person passes away. So we do that for estate planning purposes.
Is that so? passes away or if they went into a coma, would it also come into effect then as well?
Not normally. There are different arrangements about what happens when somebody is alive but loses legal capacity. So we have other things that we put in place to protect those people. We would have an enduring power of attorney, an appointment of an enduring guardian or a medical health guardian or a medical attorney, depends on the state what they're called, but they're all the same basic thing, that you appoint somebody who's got the authority when you can no longer look after your own affairs. Somebody else that you trust is appointed to make decisions and to do things on your behalf. Now, that's different to a will because a will only kicks in when somebody passes away, and it talks about what happens to all of your assets after you die. So anybody who's being an attorney or a guardian still have to look after things for your benefit while you're still alive.
You made headlines recently in Sky News. Can you explain how there was some confusion around grandfathering of testamentary trusts in Labor's budget?
Yeah, so bear with me because it might get a little technical here. But so we talked about discretionary trusts. These are the ones where the trustee has the power to decide what happens to the income and the assets, and the beneficiaries don't have full control over those assets. Now, the government decided that they didn't like these trusts because they thought they were being used to minimise tax. And to a certain extent, they're right. That is one of the budget decided that these discretionary trusts, it wanted to tax them at a rate of 30% on any income that is distributed out of those trusts to the beneficiaries. So that's now going ahead. For family trusts, those ones where we said they're currently set up and working under a trust deed at the moment, where there was a lot of complaining, lots of complaining anyway about the whole thing, but where the government originally also said that was going to apply to testamentary trusts, so the ones that we set up in a will. Now, the problem with that is, remember, those trusts don't come into existence until the person actually passes away. So even though the government said they were going to grandfather existing trusts and they were going to be protected from these new changes, because in testamentary trusts they don't come into existence until the person passes away, i.e. in the future, that means anybody who's written a will at the moment that has a testamentary trust would have had to go back and probably review that and rewrite it. But the real problem is that there was a small group of people who have written a will like that with a testamentary trust but can no longer change their will because they've lost the legal capacity to do that. They've developed dementia, or they've had an accident, or they're in a coma, or doing whatever. So these poor people they're the ones that I was really trying to highlight, and that was what I got on the news about and in various media pointing this out, that these poor people, through no fault of their own, had legitimately planned their affairs. Then they've unfortunately developed an illness or had an accident. They're suffering, their families are suffering, and now they're stuck. There's nothing they can do to fix that. So the good news is that partly, I hope, through some efforts of mine, but also some other problems that were brought out about these types of arrangements, the government has backed down about it's going to treat testamentary trusts. So testamentary trusts are not going to be taxed this way, but the family trusts, the ones that are currently in existence that we set up today, they will be taxed that way. So at least we had a win on the estate planning side, that the trusts we would set up under a will are not going to be impacted this way.
Are you seeing any movements already? So for the discretionary and family trusts that have been set up, you mentioned it looks like that's going to move ahead with this 30% tax. Are people already acting on that, or are they waiting for a particular point in time?
There's a lot of talk. It's a little early just yet for people to start moving because we're still waiting to see the final legislation, although that's now working its way through the Senate and going through the process. There's also going to be some transitional arrangements that will allow people the ability to rearrange their affairs. So we need to see the detail of that before we can finally exactly work out a plan for what people should do if they have a family trust that's going to be. But having said that, I'm seeing that there are a lot of people who are tossing different structures, different ideas around. I think we may need to potentially do some restructuring, but the other thing, just remember what I also said about these trusts, that they're very flexible. You can set them up for different reasons. Now, if you set them up to be trusts that were distributing income because they owned a business or an investment asset or something like that, then you probably are going to have to look at distributing them again. But if you set them up for the primary purpose of protecting assets, remember I said they're very good at protecting assets because people can't sue you for them. If their primary purpose is more about asset protection, then you're probably not going to need to have a look at it. But either way, they probably need to be reviewed and looked at, particularly once we see the detail of what's going to be in the government's legislation.
And what else have you seen from the budget proposal that is particularly poignant and front of mind for estate planners at the moment?
Well, there was a very nasty little thing that got slipped in right at the very end where the government did a deal with the Greens. So anybody who was buying property through a self-managed super fund and were borrowing money to do that, there used to be arrangements. Yeah, there were rules about what you had to do, but that was a legitimate option. That's now been cancelled. So that was unexpected and unfortunate when that came through. The other big changes that got a lot of airtime and which are going through are the changes to negative gearing and the changes to capital gains tax. And for people who are investing in property, I think everybody understood that the government's policy framework was about trying to make property more accessible to young first-home buyers and so on. So that's fine. It's unfortunate that they extended the rules about capital gains tax, not just to property, but across all asset classes, including crypto. So what it means is that, if people are listening to this podcast who are obviously buyers or interested in buying crypto, then it's changed the rules around the CGT treatment of how crypto assets are going to be dealt with by the tax office, probably for the worse. So that is a pretty unfortunate outcome. It's basically taken us back to the old days of where you had to use an index base rather than only pay half the cost, half the capital gain was taxed. So it basically means there's going to be more tax payable as a result of that.
Sorry, what do you mean about that last part there? You have to use an index and half the tax payable, sorry.
Well, until the budget, there were two ways you could decide to calculate your capital gains tax. You could either say, I bought something for $1 million and I sold it for $2 million, so that's a $1 million capital gain, and I would pay tax on half of that is option A. So I would pay tax on half of that, and that $500,000 would be added to my assessable income, and I'll pay tax at my marginal tax rate, whatever that might be for that. Option B would, instead of saying, I'm just going to calculate half of it and pay tax on that, option B was to say, well, we would index the cost base. So let's say I bought it 10 years ago. If you allow for inflation, the $1 million I paid for it 10 years ago is effectively now indexed up to be $1.3 million. So I've now got a capital gain for tax purposes of $700,000. And I've got to add that $700,000 to my taxable income. So basically what's happened now is option A is gone and we're stuck with option B. So the end result, not always, but in a lot of cases, is that you probably wind up paying more tax.
Yeah, I've also heard people talking about it could be more effective to hold broad-based funds if you're looking to get a selection of assets, because at least with an index, you're not having to, you can get indexation of the cost base on buying the whole fund, and you can offset that against the gain. But if you've got, let's say, multiple positions that you're managing independently, it can be less tax effective because you don't get the same indexation of your cost base to offset as well. So,
and this is really a conversation everybody should have with their accountant about, because each asset is separately indexed or separately assessed. So you've got to work out, what have I got? What am I buying? What's the tax implication for it? So you need to keep proper records of everything that you bought and the time when you bought them. So that's really important for those who are buying and selling crypto assets as well. You must maintain good records. And particularly if you're transacting and you're doing some trading, let's just assume you don't qualify as a trader where it's all dealt with on income account. Let's just say you're a normal tax person where you're doing a bit of buying and selling. You must record every transaction and what you bought it for and the timing of when you bought it.
Yeah. So I've been speaking to a few estate planners over the last few weeks, and I thought in the crypto sector, or digital asset sector, as I was calling it, that was a term somewhat unique to crypto. Of course, that was foolhardy and not the case. Digital assets means something quite different in estate planning, something a lot broader. So could you define for us what are digital assets in the estate planning world?
It's pretty much anything online, and that can be everything or online or stored on a computer one way or another. So that could be anything that you've got on your computer, on your laptop, on your mobile phone, on tablets, other storage devices, anything that could be stored as a file. It could be things that you created, you own, you do yourself. It includes your email, all your online accounts. So, every online account you've got, you might have digital photographs that are stored online with Google, for example. All of those photos are considered as digital assets as well. Anything with online accounts, online files is treated as a digital asset, just as crypto accounts are also treated as digital assets because they're an online file of some sort, albeit stored on a blockchain rather than in a sort of a normal cloud service arrangement. But, NFTs, stablecoins, whatever it is, they're all regarded as digital assets. Now, there is a newly emerging digital asset framework that the government has sort of done some work on recently that, let's not bog down on the detail of that today. But generally speaking, from a legal point of view, all of these assets are regarded as just like any other asset when it comes to estate planning. Things that you own, they're things that you can pass on to other people in your will, and there are rules about how you can pass them on and practicalities that you've got to take into account as well. So crypto in particular is not legally treated as currency. It's not like money, which has its own particular set of requirements. So it's treated as just another digital asset. There is the possibility that if the Reserve Bank brought in a central bank digital currency, then that might be treated as currency for the purposes of the law. But otherwise, all crypto assets are basically treated as just another asset that you own. So that's something else you need to think about from an estate planning perspective. That's often the conversation we have with people.
Yes, spot on. I think the criteria for a currency is it has to be accepted as legal tender for goods and services, but also you should be able to pay your taxes in it. So the term of a cryptocurrency is a bit of a misnomer. Hence, we moved to the digital asset term, but turns out the estate planners have already taken that one. So we'll have to go back to crypto, I think. So for somebody that's got a position in Bitcoin already, maybe they're contemplating getting a position in Bitcoin or other digital assets and crypto assets, what happens if they've got a will and they die? And what happens in the scenario? I read one of your posts, around 50% of people might actually die and they don't have a will in place. What happens in both of those scenarios?
Okay, so let's talk about what happens if you die without a will. The legal term for that is that you are intestate. You die with intestacy. So where you've not made a will to talk about what you want to have happen with all of your assets and deal with things, then the government decides is the short answer. So every state has its own set of laws around this, but they're broadly the same. There's a statutory formula that says if you're married, it goes to your spouse. If you've got kids, if you're not married, but you've got kids, it goes to them. It sort of works its way down through the formula, basically getting further and further out in your extended family until they run out of options. So the simple scenario is that if somebody dies with a spouse and they don't have a will, everything just goes to their spouse. The worst case scenario is that if you die without spouse, children, parents, nieces and nephews, uncles and aunts, about as far as that. If you die in a scenario with none of those people around you, then all of your assets go to the government, the state government. So that's not a great outcome. So people generally don't like that idea. They'd like it to go to somebody, even if it's not their family. So for most people, it's a really good idea to make a will. So about roughly half the population at least have made a will, and that's a good start. Unfortunately, in many cases, it's a will they made that's 20 years old and it's gathering dust in a drawer somewhere and it needs to be updated, but at least they've got something. So when you die with a will, the basic process is that, first of all, we need to get a court order to sign off that this is a valid will. It's the most recent will. It wasn't updated by another will that came along, and it meets all the technical requirements for a will. So that's called, in legal terms, we say we're applying for a grant of probate. And when the probate order comes through, it's basically to say that the will is recognised as legitimate, and hopefully the people who were appointed in the will as the executors of the will, we'll talk about them in a minute, that the executors now have the legal ability to come in and take control of the dead person's assets. Their job is to take over the control of the assets, They have to pay off any expenses or debts that are outstanding. And then with everything that's left, they have to distribute the assets according to the instructions in the will. So sometimes there are specific gifts where you say, I want to give my jewelry to my daughter, or I want to give, all of my crypto to my cousin, or whatever it might be. You've got fairly wide options on how you do things. So we give specific gifts, and then we have a bucket of everything else that's left at the end that's called the residue, the residuary of your estate, and you sort of generally give all that to somebody, or you can divide that equally between your kids, or you can even put it into a testamentary trust, now that we've all learned about testamentary trusts as well. So you might decide to do that because rather than giving it to people, you want it to be held in a trust so that it's there for their benefit in the longer term, but you've protected those assets and, they're there for them and their future generations to have for their benefit as well. So we've got a lot of flexibility in what we can do in a will, and that flexibility basically applies to every asset that you own, how you want to treat it, where you'd like it to go, what you'd like to do with it. And it's the executor's job to come in and basically organise all that. It's largely an administrative job to sort of organise all those assets and distribute them, pay off expenses and so on. The good news is that executors are allowed to use professional help. So they often use people like me as a solicitor to help them do that. They might use an accountant to help them with some, because they've got to do tax returns and other financial things as well. And they can use other service providers to support them in all the responsibilities that they have as an executor. So, they've got big responsibilities, but they can get help.
One of the interesting problems that we've been running into through the discussions with estate planning firms is when a person dies, the will is made a public document. And so with certain assets like crypto, the custody is in the hands of the person who has the private keys, or the seed phrase that gives you the private keys. Now, how do you propose that testators who are passing on the assets, crypto assets, how can they navigate this type of a problem, do you think?
I think the best way to think about it is, let's do an analogy. If somebody is going to pass away, they own an investment property, but they've locked away the keys somewhere and nobody can get access to that investment property, it's kind of useless. There's not much you can do with it. So this is the real crux of the issue, where people have crypto assets or really any sort of digital assets that have security as an access prevention measure on them of some sort. Even simple things like just basic passwords as well. It's the same fundamental issue. If you can't access the asset, then it's basically gone for all effective purposes. So what we are recommending more and more is that people who do have digital assets, and particularly crypto, that they have to think very carefully about not only when I make a will, who do I want the assets to go to, but how am I going to manage that process? What is the best way to facilitate the easy transfer of the assets so that, first of all, they can be transferred, like the logistics of it are possible to do. And secondly, it happens as smoothly and as painlessly as possible. And that's where I think services like BlockByte are fantastic, because it's custom designed to help people make sure that their assets are being properly looked after and supported as they pass through to their beneficiaries. So bottom line, if you don't have a service like BlockByte, or you're not very organized yourself and you've got a proper record somewhere of all the keys and you've managed your own security protections around all of that yourself, you could very well just lose all of those assets and they won't be there for the benefit of your future generations.
Wow, that was like you read it straight from our sales script, Anthony, so I really appreciate that. What responsibilities does an executor have? I think in one of our earlier conversations, you mentioned there's a certain liability or risk that executors have, whether it's managing digital assets or any other type of asset for an estate.
So executors are the people who are legally responsible for looking after the estate and managing it according to all of its requirements. So they've got to collect the assets, they've got to pay the expenses and the debts. So if there are any debts or if there are any borrowings or geared assets, that they all need to be resolved and dealt with as well. So the executor basically steps in to take responsibility for all of that. And then they have to distribute everything that's left according to the instructions in the will. So they have a legal responsibility to the beneficiaries of the estate to make sure that they do everything properly. They have to keep proper records. They've got to keep files, accounts, details of everything that's gone on. Now, there's a whole process about doing things properly. Now, if executors don't act properly, then they can be held legally accountable to the beneficiaries. So if an executor, for example, sells an asset, let's say it's a house, for below the market value, then the beneficiaries are entitled to claim that personally from the executor. Potentially, they can take them to court and say, well, you failed in your duties. I lost out because you failed in your duty to me, so therefore you need to compensate me for that. So this is one of the reasons why it's important for executors to rely on proper professional advice and quality service providers to make sure that you can see a scenario where an executor might step in, and even in a case where, let's say, the testator, the person who made the will, has been organised and looked after their keys and their details and all of their security side of things fairly well, but the executor is not familiar with crypto and doesn't know how to manage it, that's a real trap for an executor. So you've got to be very careful about making sure you get proper advice and proper support to make sure you fulfil your responsibilities to the beneficiaries, because if you lose those assets through the fault of the executor, you could be personally liable for that.
Yeah, absolutely. It's actually quite scary. I think it sounds like quite a big responsibility when you are chosen to be an executor, that you shouldn't just blindly accept it and think nothing of it. That you really should consider that you're financially and legally liable to manage that estate.
Yeah.
So blockchains like Bitcoin and Ethereum, Solana, they're ways of putting financial transaction information onto the internet, onto the blockchain, and keeping it somewhat tamper-proof. At least with Bitcoin, it's the most decentralized ledger that we know of. Do you think that in future we might see wills getting uploaded onto the blockchain and cryptographically signed, or is that a pipe dream?
Well, it's very much a question for the future because you can't do it right now. At the moment, the laws around wills are basically pretty much the same laws we had 150 years ago, 200 years ago. So a will, by and large, there are some exceptions, but it gets difficult. By and large, a will has to be written on paper. It can be typed, doesn't have to be handwritten, but it has to be wet signed by the person who made the will. And it has to be wet signed by two witnesses who were present when the testator signed the will as well. So that original hard copy will is a very important document. And that's why often solicitors hold those in our safe custody, because they are really important documents. And that original document is the one that we have to send to court when we apply for probate once the person's passed away. So the hard copy of that original document with the wet signatures is a very strict requirement. If it's gone missing or it's disappeared, there are ways to deal with that. But basically, we have to go to court and try and convince the court that we've got a legitimate copy, or we've got some other means of proving what the person's intentions were. And that's far from guaranteed, and it's expensive and it's costly to sort of do that. So right now, to answer your question, you could not store a will on the blockchain. However, what I think the blockchain does offer is that sort of measure of integrity and the validity of the document, and the fact that it is the most recent version or the most recent iteration of the document. Those are very attractive things in terms of proving the reliability of a will to a court. So there's probably a lot that we should be looking at to make better use of blockchain to back up these sorts of documents. But wills have to be wet signed at the moment. There are lots of other contracts and things that we can e-sign. Wills basically have to be wet signed though. So we're stuck for the time being, I'm afraid.
Oh dear. I like the idea that everybody would have an individual private key signature and that stays with you from birth, and you could authorize and sign things that way, and it becomes much less forgeable than a signature. It's a truly unique identifier. But also, I think with the wet signatures and having the witnesses, somebody's got a gun pointed to your head. You're being witnessed through a computer screen like we're having a conversation right now. I could cryptographically sign it, but if there's not two witnesses present, I guess in person, the technology doesn't really overcome that problem. So it's a bit of a conundrum. So more than 20,000, it's at least 20,000 SMSFs now hold crypto. And it's one of the main drivers for people setting up an SMSF. How does crypto in super get passed on to beneficiaries in a will, or is it completely separate?
Well, like I said, crypto generally is treated like any other asset for legal purposes, for now at least. But assets that sit inside super funds, there are different rules around what happens with super. So take a step back. When you write a will, the assets that become part of your estate, the assets that flow in under your will to become part of your estate, are the things that you own legally in your own name. Things that you've got inside your super fund, whether it's an SMSF or a public offer fund, doesn't matter. You don't legally own the assets inside the super fund because the trustees of the super fund are the legal owners of it. Even if it's you anyway, because it's a self-managed fund, it doesn't matter. They're legally separate. So all those assets inside your super fund are dealt with differently than under a will, the assets that you own personally in your own name. So what that means is that there's a different process when somebody passes away about what happens to your superannuation assets. So there's a thing called the death benefit, which is the value of your account in your super fund plus any insurance payouts. So a lot of people have insurance inside their super fund. So if you get a payout from insurance, the insurance payout plus your account balance together make up what's called the death benefit. Now, your death benefit, generally speaking, has to be paid out of the super fund when somebody passes away. It can be paid out often fairly quickly. In easy terms, it can be cashed out and paid out almost straight away in a lot of cases. There are some tax rules depending on who gets the money about whether that money is taxed or not. So if the death benefit goes to your spouse, there's no tax. But if the death benefit goes to an adult child of yours, it is going to be taxed. So these get sort of complicated issues around what happens with all of that. There is an option to say, I want my death benefit to go back in with my will and be dealt with as part of my estate. But you need to make what's called a binding death benefit nomination to the trustees of your super fund, which is basically an instruction you give them about what you want to have happen with your death benefit when you pass away. And one of the options is that you can direct it to come back in under the will. And one of the reasons why we might do that is, let's take a scenario where somebody's created a will and they've set up a testamentary trust because they want the trust to hold the assets for their children and their grandchildren and future generations. And they want the super money to come in and be a part of that as well. So we might direct the super money to come in under the will for that reason. That's one example. So there are options around how that all gets dealt with. And that's all part of the estate planning conversation we have with people when we say, what are the assets you've got and what structures are they held in and what's going to happen with those when you pass away? So, it gets a bit technical, and I hope I haven't sort of lost people in all of the detail of all of that. But it is an important conversation to have with your solicitor, your accountant, your super fund around, well, what will happen when I pass away? So definitely important to discuss.
Anthony, it's been a really insightful conversation. I've got one more question for you. If there's one thing you would want to ask or tell every family that has digital assets and every advisor who's dealing with a family with digital assets, what would it be?
I hate to say it, but I'd suggest think about the worst case scenario. Nobody wants this to happen, but just imagine that big blue bus outside has got your name on it and it's coming for you and you get taken out by the proverbial. So what would happen in that situation? It's possible. It does happen from time to time. So what would happen in that scenario? Are you ready? Are you prepared for your assets? Do you know what will happen to them? Do you know where you want them to go? Are you ready for that? Have you got the records? Have you got the details? Have you got the right arrangements in place to deal with that? Even if the scenario where, let's hope that that's a very unlikely scenario, even though it's possible. Let's hope that we all live a nice, long, happy and, prosperous life. But the peace of mind of knowing that you have thought this through, you've worked out what the options are, you've discussed it with professional advisors, you've looked at the best options for getting support just in case it happens, that peace of mind is invaluable, knowing that you can go and sleep easy at night, knowing that you've actually worked this through, you've done the right thing by your family, by your loved ones, by the people that you want to be there after you pass away, whenever that might be. So the security and the knowledge that you've worked that through and you've done the right thing is The people I work with, they find it very personally rewarding. Even where people have illnesses, I can't always help them, obviously, with their illness, but I can give them the confidence to know that they've organised things and they've done the right thing by the people that they love. So that is a truly valuable thing for people to have.
100%. If you're listening to this and you want to find out more about what Anthony does, head over to wealthlawyers.com.au. And if you're specifically looking at how to pass on Bitcoin or your digital assets to loved ones, you can find more about our services at blockbyte.com.au as well. Thank you so much for your time, Anthony.
Been a pleasure. Thank you very much, James. I really enjoyed our chat.